Does that work? Can you hear me now? Okay. Good morning, and welcome to the joint hearing by the Committees on Public Safety on the proposed initiative to repeal the death penalty. The purpose of this hearing is to educate ourselves and the public as to the specifics of the ballot measure and to provide a forum for public participation. We will not be voting on any measures today or making recommendations or changes to the initiative. I recognize that this is an emotional issue. I want to remind everyone to be respectful of divergent points of view. The members look forward to hearing testimony from both sides, as well as the findings from the Legislative Analyst's Office and comments from the public. I also want to thank the members of the Public Safety Committees for taking the time to participate in this informational hearing. So at this point, I will invite Assemblymember Quirk, who's here today, if he wanted to make a brief statement.
I'm just trying to learn about the initiative, so thank you very much for those of you who have come here today to testify. Thank you.
You may have to repeat it because I don't think I had you on. Try one more time.
I just want to thank everyone who's here today to speak to the initiative and those in the audience who've come to hear. And I intend to learn a lot about the initiative today. Thank you.
And as other members come, they'll also allow them to make some comments. And so we will begin with Anita Lee, and Senior Fiscal and Policy Analyst at the LAO's Office, and Drew Soderberg, Managing Principal of Legislative Analyst's Office. You have 15, no, you have a half hour. Well, 15 minutes. We may have some questions.
Great. Good morning, members. You have a handout that the sergeants, I believe, have passed out to you. Is that correct? Perfect. Yes.
Right.
And so we're going to use this handout as a guide for our comments today. If you turn to page 1 of your handout, this may look familiar for those of you who are at the firearms hearing. This provides an overview of the LAO's role in the initiative process. And so the LAO is really involved in 2 different stages of the initiative process. First, state law requires that our office work with the Department of Finance to prepare a joint impartial fiscal analysis of each initiative before it can be circulated for signatures. State law requires that this analysis provide an estimate of the measure's fiscal impact on the state and local governments. The fiscal analysis must be submitted to the Attorney General within 50 calendar days of the initiative's submission date. A summary of the estimated fiscal impact is included on the petitions that are then circulated for signatures. The next time the LAO is involved is when an initiative has collected sufficient signatures to qualify for the ballot. At that point, state law requires our office to provide impartial analyses of all statewide ballot propositions for the statewide voter information guide, including a description of the measure and its fiscal effects. We are currently in the process of preparing those materials. If you turn to page 2 of your handout, we will provide some background related to this initiative. First-degree murder is generally defined as the unlawful killing of a human being that is 1, deliberate and premeditated, or 2, takes place at the same time as certain other crimes, such as kidnapping. First-degree murder is punishable by a life sentence in state prison with the possibility of being released by the state parole board after a minimum of 25 years. However, first-degree murder can be punishable by death or life imprisonment without the possibility of parole when specified special circumstances of the crime have been charged and proven in court. Existing state law identifies a number of special circumstances that can be charged, such as in cases when the murder is carried out for financial gain or more than one murder was committed. Death penalty trials are generally divided into 2 phases. First, determining whether the defendant is guilty of murder and any charged special circumstances. And then second, determining whether the death penalty should be imposed if the defendant is convicted of murder and a special circumstance. Death penalty cases ordinarily involve extensive legal challenges in both the California Supreme Court and the federal courts following the death sentence. These proceedings can take a couple of decades to complete in California. Turning to page 3 of your handout, since the current death penalty law was enacted in California in 1978, 930 individuals have received a death sentence. Of these, 15 have been executed, 103 have died prior to being executed. 748 are in state prison with death sentences, and 64 have had their sentences reduced by the courts. Most of the offenders in state prison are at various stages of litigation related to their cases. Condemned inmates generally cost more to house than typical inmates due to increased security requirements, such as being housed in single cells and being escorted at all times by 1 or 2 officers while outside their cells. The state prisons generally use lethal injection to execute condemned inmates. Because of legal issues surrounding the state's lethal injection procedures, executions have not taken place since 2006. The state is currently in the process of developing regulations to allow for executions to resume. If you turn to page 4 of your handout, the proposed initiative contains 3 major provisions. First, under this measure, no offender could be sentenced to death by the state for first-degree murder. The most serious penalty available would be a prison term of life without the possibility of parole. Second, the measure specifies that offenders currently sentenced to death would not be executed and would be resentenced to a prison term of life without the possibility of parole. The California Supreme Court could transfer all of its existing death penalty legal challenges pending before it to the state's Court of Appeals or trial courts. Third, the measure specifies that every person found guilty of murder must work while in state prison and have their pay deducted for any debts they owe to victims of crime, subject to state regulations. Because the measure does not change current state regulations related to inmate work, existing practices would not necessarily be changed. The measure increases from 50% to 60% the maximum amount that may be deducted from the wages of inmates sentenced to life without the possibility of parole for any debts owed to victims of crime. Turning to page 5 of the handout, we shift our attention to the major fiscal effects of the proposed initiative, and it really breaks down into 3 different areas. And so first we look at the fiscal impacts related to murder trials. The measure would reduce state and county costs associated with some murder cases by 1, shortening the duration of some trials, and 2, reducing costs incurred by counties for prosecutors and public defenders. In total, the measure could reduce state and county costs for murder trials by several tens of millions of dollars annually on a statewide basis. The actual reduction would depend on various factors, including the number of death penalty trials that would have otherwise occurred in the absence of the measure. The second area where we'll be taking a look is fiscal impacts related to legal challenges to the death sentences. These are the appeals process. Over time, the measure would reduce expenditures by state agencies participating in the legal challenges to death sentences by about $55 million annually. These reduced costs likely would be partially offset in the short run because some state expenditures would probably continue until the courts resolved all currently pending legal challenges. Third, we have the fiscal impact related to state prisons. The measure would result in a somewhat higher prison population and higher prison costs as formerly condemned inmates are sentenced to life without the possibility of parole. However, these added costs likely would be more than offset by reduced costs from not having to house hundreds of inmates on death row. The net effect of these fiscal impacts would likely be a net reduction in state costs for the operation of the state's prison system of several tens of millions of dollars annually. The actual reduction could be higher or lower depending on the rate of executions that would have otherwise occurred. So in conclusion, if you turn to page 6, in total, we estimate that this measure would reduce net state and local government costs related to murder trials, the legal challenges to death sentences, and state prisons. These reduced costs would likely be around $150 million annually within a few years. This reduction could be higher or lower by tens of millions of dollars depending on various factors. With that, we're happy to answer any questions you might have.
Okay. Did you have anything to add, Mr. Soderberg?
I don't at this time. I'm just here to assist with any questions that might come up.
Okay. You're wingman today.
Correct, yes.
We've been joined by Senator Mark Leno and Senator Jeff Stone, and of course our esteemed colleague, the Chair of Public Safety, Lonnie Hancock, and we're also joined by Mr. Monning, Senator Monning. Ms. Hancock, did you have any opening statements you want to make, and any of the other members?
Looking forward to the conversation today.
Okay. Mr. Leno?
Thank you, Ms. Lee. Any significant differences between this measure and the one that was on the ballot, I think, 4 years ago?
They are quite similar. One of the major differences is the proposition in question, Proposition 34, did require that a certain portion of the savings be deposited into a special fund and be used for specific purposes. This doesn't have that component. It's just broadly the elimination of the death penalty. Any reductions in costs or savings would go to the general fund.
I have a memory that estimates of savings for that measure was approximately $200 million a year, because the figure $1 billion over 5 years stayed in my mind. Is there any reason why this one would save any less money than Prop 34?
So I believe you may be thinking of the estimate that was put together by the proponents of Prop 34. Our estimate at that time was actually about $130 million, and so it's gone up a bit to $150. And that's largely because of changes in costs that have happened since Prop 34.
I'm still in the same ballpark.
Correct.
Thank you.
Okay. And we're now joined by Senator Joel Anderson. We're into question phase now.
Yes.
Ms. Hancock.
Thank you very much. I do have a couple of questions that the analysis made me think about. You said that 64 people on death row have had their sentences reduced by the court. What exactly does that mean? How does that happen? Were any of them exonerated, or did they simply have their sentences reduced?
So when individuals go through, individuals are entitled to an appeals processes, and we'll actually go more in depth in this afternoon's hearing. And so as part of that appeals process, there are presentations, one related to direct appeals, which is an automatic appeal of the verdict that happened. And then there's a second series of challenges that are called habeas, factors outside of the case. When the courts are looking at it, when the courts are considering the appeals, the courts may decide to resentence the individuals, and those are the 64 that you just mentioned.
Do we know if any were exonerated, or was their sentence simply changed from death to life imprisonment without parole? Do you have any of that data?
That's something that we could look into. We could work with CDCR. Offhand, I'm not aware whether any were exonerated. I believe most were resentenced to life without the possibility of parole, but we can get back to you on that.
Yeah, I'm interested in how that breaks down. The other question was, you note that state prisons usually use lethal injection to execute condemned inmates, but because of legal issues surrounding California's lethal injection procedures, executions have not taken place. Could you comment on that a little bit? What are the options here? I would note, I was very interested to read in Sunday's paper that Pfizer Chemical has joined a list of companies that will no longer provide drugs for executions.
Absolutely. So in terms of the legal challenges related to that, so in 2006, the federal courts stopped executions after ruling that the state's lethal injection procedures were unconstitutional. Between 2007 and 2010, the state did promulgate regulations. However, the courts ruled that the state did not follow the Administrative Procedures Act appropriately, and when revising the procedures. As a result, executions couldn't continue. Recently, in 2015, the state has begun that process all over again in terms of promulgating the regulations. And the state is currently in the public review process. And in terms of the question related to the news article, that's something that we are certainly aware of. And as we're continuing to prepare our ballot materials, we're going to work with CDCR to have a conversation about what that means.
Okay, thank you. I do realize some of these may not be fiscal issues, but other kinds of issues. But thank you. I was interested in that.
Mr. Quirk.
On page 3 of your report, it says, condemned inmates generally cost more to house than typical inmates due to increased security requirements, such as being housed in single cells and being escorted at all times by 1 or 2 officers. outside their cells. Would any of that change if they were given life imprisonment without the possibility of parole?
So it would be up to the Department of Corrections as to whether that would change. We've had discussions with them, and inmates are generally divided into two categories, grade A and grade B, and that sort of helps the department assess whether when they get resentenced to life without the possibility, or should they get resentenced to life without the possibility of parole, how they'd be housed. When taking a look at it, to the extent that CDCR chose to house them consistent with the way it's housed other LWOP prisoners, it would result in significant savings. We estimate savings in the several tens of millions of dollars annually.
But we don't know what fraction of those changed from death penalty to life imprisonment without parole. We don't know what fraction would be housed in this way or another way.
Currently, the data provided by CDCR suggests that about 95% of the inmates who are on death row would be eligible for housing with other inmates, so a significant portion would be housed at lower costs. Okay. And even those who aren't eligible for double celling would likely also be subject to less security requirements if they were sentenced to life without the possibility of parole.
Great, thank you.
Mr. Leno, you had a follow-up question?
Thank you, Mr. Chair. As we're having this conversation, all sorts of memories from Prop 34 are coming back to mind, and I just wanted to ask if you could comment on some of the, I guess you call them talking points of Prop 34. There was the suggestion at the time that, on average, states without the death penalty had lower rates of homicides than states with the death penalty. Is there any way to document that or confirm or reject it?
So around the time that Prop 34 was released, the National Academy of Sciences did a review of the literature surrounding the death penalty and its effects on the murder rate, and they raised serious methodological concerns with all of the studies that they encountered. There's some studies that suggest that the death penalty reduces the murder rate. Like you said, there's other studies that suggest that it could possibly increase the murder rate. However, like I said, the National Academy of Sciences raised serious concerns with all of those studies and came to the conclusion that we just have no good evidence about what effect the death penalty has on the murder rate.
Good to know. Has anyone ever sentenced to life without the possibility of parole ever been released from prison short of exoneration? Is it what it says it is, life without the possibility of parole?
I would have to check into that to be sure. I think the only way it would be possible for someone who has been resentenced to life without the possibility of parole to get would be through an appeal, which I think is relatively rare. There was a cohort of inmates who I think were resentenced to life with the possibility of parole after the death penalty was eliminated in the late 70s, or excuse me, the early 70s by the U.S. Supreme Court. But whether somebody who's been resentenced to life without the possibility of parole could subsequently get their sentence reduced would really depend on their legal appeals. And so I think it'd be very difficult to know for certain.
But short of exoneration, it would have to be a mistrial.
It would have to be a mistrial, or they would have to go back and somehow prove that the special circumstances they were convicted of didn't apply.
Got it. Along that same argument that the death penalty does not deter homicide, which you've now put in question, as you have that the death penalty does not deter or deter, that what does deter is the risk of getting caught. And I remember a figure of only 1 in 10 homicides being prosecuted in California. Is that anywhere near the truth?
If I recall correctly, I believe I'd be happy to take a look at that statistic. Offhand, I believe that about half of reported crimes are solved, but I don't know if that rate changes when you zero in on murder specifically. But I'd be more than happy to look at any data that you have.
We often hear that the death penalty impacts those from ethnic communities disproportionately high rates. Do we know what percentage of those who are sentenced to death are black or Latino?
Those statistics are available. We don't have them here, but we'd be happy to provide them.
And then, if you could, I'd also be the subset of those then who are condemned to death, and then that very small proportion of those who are actually executed. I wonder if those percentages change at all among those who are actually executed.
Yeah, we'd be happy to check into that.
Okay. Thank you, Mr. Chair.
Okay, thank you. Mr. Monty?
Thank you, Mr. Chair. I apologize, I didn't hear your affirmative presentation, so if I cover ground you covered, just let me know. But taking a step back, do you have data on how many states in the United States currently have a death penalty law in effect? You know?
Yes. So approximately 31 states have the death penalty, and 19 do not.
And have any within the last 10 years converted from having a death penalty to not having a death penalty? The reason, is there any data that shows any savings on fiscal savings of states that have gotten rid of a death penalty? Is that information you could?
So in terms of the first question, recently there have been states that went from having the death penalty to not having the death penalty. An example is Connecticut, which I think in about 2012 abolished their death penalty. Another one is Maryland in 2013, and there are a few more. In terms of savings, we are not familiar with the prison system and the court system in those states. I think especially for the ones that are more recent, I think they're still going through the process of what it means for them. And so for one of the states, I believe Illinois is one of them that also kind of went that direction. As part of their budget process, they're starting to note some changes. So, for example, as part of their budget process, I think we noted a $5 million reduction in the budget to their California Appellate Defender's Office. Mm-hmm. But again, if we're looking at savings related to elimination, we would want to pay attention to net changes. And so that really relies on an understanding of what the court structure is like, how their attorney compensation structure is, and then what their prison system is and how they dealt with the individuals.
Thank you. Yes.
And just to add on, it really does depend on the way the initiative would be operationalized in each state. So to give you a sense, were this to pass, the state would be faced with a choice of whether or not to eliminate funding for the Office of the State Public Defender, which currently represents condemned inmates in certain portions of their appeals. The state could, on the one hand, choose to eliminate the funding and score the savings. On the other hand, it could choose to direct the Office of the State Public Defender to represent other inmates in their appeals, and then the savings wouldn't necessarily be scored. Likewise, as I mentioned earlier about the correctional savings, on the one hand, CDCR might choose to maintain its current security policies for the resentenced inmates. On the other hand, they might move them throughout the system and create savings.
Thank you. And I know you will be focusing on this perhaps more this afternoon, but is it fair to say, and I think it's in your presentation, if voters choose to eliminate the death penalty in California, with that goes the elimination of certain automatic appellate rights afforded to somebody convicted on a death penalty case. Is that correct?
Correct.
And as such, while they're no longer sentenced to death, they can be found guilty, sentenced to life without possibility of parole. It doesn't eliminate all appellate rights. It just eliminates certain automatic appellate rights. Is that correct?
So as inmates who are sentenced to life without the possibility of parole, for example, they can appeal to the Court of Appeal, and then that could then be appealed to the Supreme Court. The process is just different. It would be more in line with kind of the traditional approach.
So it wouldn't eliminate all appeals, but it would eliminate certain automatic appeals, and that's where you are able to score certain savings to the taxpayers of California.
Correct.
Great. Thank you.
Thank you.
Mr. Chair.
Mr. Leno, would you follow up to your follow-up question?
Thank you, Mr. Chair. You're very generous and gracious. As you've pointed out in your presentation, we have only executed 15 of all the 930 who have been sentenced to death since 1978. Do we know of those 15 in California? I know it's a very small subset. Subsequent information, we've learned that we've executed any innocent people?
We do not. We're happy to kind of have that conversation with CDCR and follow up with you.
And can you give us any information with regard to other states?
Yeah, that's something we could look into. I know, for example, the Death Penalty Information Center, I think, collects information on that, on trying to assess whether or not somebody who's been executed has been exonerated in the past. We're happy to look into that. Obviously, there are difficulties because to the extent the person has been executed, obviously their legal case is stopped, though people still do research to try to establish one way or the other. But we're happy to look into that.
And so looking at the larger number here of the 930, how many have been exonerated?
We are aware that 64 have been resentenced to something other than life without, or other than death, but the number of those that have been exonerated isn't clear. I believe most have been resentenced to life without the possibility of parole. But again, we're happy to look into it, to whether any have been actually exonerated.
Can you give us some ideas as to why someone would have been taken off of death row, but not exonerated?
Oftentimes it'll be the case that their attorneys have shown that they aren't eligible for the death penalty for whatever reason, or they may have cast doubt on the special circumstances they were convicted of that make them eligible. So I believe one of the examples, and I think Anita could correct me if I'm wrong here, is that people who have a limited mental development aren't eligible for the death penalty. So to the extent that their attorneys are able to show that their client fits that description, that would be something that could make them ineligible for the death penalty.
I'm sorry, your answer to the question, how many have been exonerated of the 930? You said you weren't quite sure.
We're not sure. We'll look into that. Offhand, I'm not aware whether any have been exonerated, but I can confirm that and look into it. And subsequent speakers might also be able to speak to that.
Good. Okay.
Senator Stone.
Thank you, Mr. Chairman, members. Can you talk a little about DNA evidence and following up with Senator Leno's question? Has DNA evidence been utilized to exonerate or attempt to exonerate condemned people? And is there any process that the state undertakes at this time to look at the 930 that have been given the death sentence to recognize the utility and value of DNA evidence and potentially exonerating those that have been already put to death? Two, there are many in the state that would argue that we really don't have a death penalty in the state at this time because of the lengthy appeals process and because of the antiquated drug protocols that are many years old. There are many more modern drugs that we believe can more humanely, which is of the interest of the state, to put those condemned to death. Why hasn't that formula been looked at rather than halting executions for 10 years now?
So on the first question about whether DNA is used, it's really up, really the review process, the legal review process is the sort of structure the state has put in place to allow inmates to contest their condemnation. I'm sure that many of the attorneys that represent these individuals have relied on DNA evidence, though I wouldn't be able to talk about specific cases. In terms of the second question about the death penalty, I think Anita can answer that.
So in terms of the protocol related to lethal injection procedures, that's currently the process that CDCR is going through. They've promulgated a series of regulations that details the protocol, the type of drugs or potential types of drugs that they're planning on utilizing. And so that's going through the public review comment, and we will see the result of that I believe, fairly soon.
I mean, pentobarbital is an old drug. For those of us that remember, in the 60s, we used to call them yellow jackets, but they were given IV. It's a fast-acting barbiturate, which is really antiquated today when you have drugs like propofol that you turn it on, somebody's unconscious, you turn it off, and somebody regains consciousness. It's a wonderful drug if it's used professionally and appropriately. It would seem that the CDCR would embrace some of these newer drugs if, in fact, the death penalty is going to continue in the state of California. And then, can you just talk about the appeals process in the state? It seems, very lengthy. Many would argue that people are going to die of old age before they are actually having their sentences carried out. What makes California different than other states? We'll use Texas as an example, where you could be put to death within 5 years of a sentence versus California. Where is the difference?
So I think there are really kind of two different aspects to think about as part of that. One is kind of the court process, and then I think the second aspect is the attorneys that are appointed to the appeals process. California has different standards from other states. From our conversations with the ABA, the American Bar Association, California's standards are kind of in the middle when you compare just the attorney standards. But then you also have the approach of the court. And so there are different states' courts will have a different perspective, and they have different processes and procedures. We have not done an evaluation of other states' processes and procedures because they can be fairly lengthy and complicated. In California, in terms of the length and the time, the state has a number, and we'll probably dive more in depth later this afternoon, in terms of having available attorneys to appoint to the direct appeals and the habeas. The backlog in terms of appointment of attorneys is particularly large on the habeas side. And so that leads to some of the delays. Then you also have the issue of procedurally moving through the court system. And so the Supreme Court balances its work between death penalty cases in addition to all of the other types of cases it receives. And if you are in another state, you might have a different priority order in terms of workload. So those are all factors that play a part.